But isn't that also, I mean, in some ways that is, in a normal court, you know, a court that has all the time to sit, someone can say, yes, that is possible. But for a court that has, you know, a time frame in which to sit, 180 days, is that possible? Can a judge, you know, allow forever and ever for, you know, witnesses to continue to sing if they prefer, in the name of giving testimonies?
Progressively, because of our attitude, there are things that ordinarily ought to be left to the discretion of the court. But progressive because of the way we are, we try to set law and rules for every mode of conduct. You must file it within this time, you must do this one, after this one you cannot amend, after this you cannot come back, after this. So for instance, what the judge will do is to look at the rules. For instance, how many times have you amended your papers since we came here? He says, no, you can't come back again. Well, he's just applying those things as stated. If you say, look, I have 15 witnesses, the judge can say, oh, it will take me too long a time to take 15 witnesses. Why don't you cut your witnesses to 2? What are they coming to testify about? You can't do that. But what does he do? Instead of, say, for instance, for him to rise by 3 o'clock, he will say, look, I'm prepared to sit till 12 midnight. Just to be able to work within that time frame.
But seeing that there's a time frame, don't you think some litigants might want to ride on that and stretch the case, knowing that after a certain time limit, that case would have to end one way or the other?
Now, what happens is that by the time the tribunal begins to sit, you are reminded of the time limit, and you are told that, look, it's in your best interest to try to work within this time limit. So what the judge enforces the rules as to every point in terms of when you can do this, when you cannot do this, when you cannot reopen your case, when you cannot come back. So for instance, if the matter gets to trial stage, you can't take the court back, because by the rules it has reached that stage of trial, then you go on with the trial. For instance, after the tribunal judgment, a lot of the cases that went on appeal to the Supreme Court, a lot of them were caught by this timeline. And there was the issue that this is unfair, this is unconstitutional, because for instance, once they come to take the case and all of that, then you are here but you are out of time. But if the litigant also is mindful of the time limit, and as counsel we are also mindful of the time limit, everybody tries to work within it. But the truth of it is that on some occasions, there is no way it's me working justice still. Because everything like this stage, after this stage, after that stage, and it goes on like that.
Well, you say that we've become difficult as a people, hence the need for us to, you know, set rules for almost every action we take, you know, to ensure that, you know, we don't abuse certain things. But how do you see that playing out here, for instance? Do you think that it's absolutely necessary? Do you really think that we can manage with the time that we have?
I think it's just, I would say we are difficult to pass up, but if you look at it progressively, if you look at where we started from, there was no time limit. People took advantage. It went on beyond reasonable time. Then time limit was set.
Is this time limit sufficient?
The time limit was shut down because of this issue that we have, that is occasions injustice. We tried to work it out, it didn't work out. We went back to time limit and now try to make it even at a higher level. So you are bound to work within that time period. But the truth of it is that if things were working normally, I mean, why is it that when we left it open, it didn't work out? They tried to limit it, it was shut down. We went back, it was open, it wasn't working. We came back again to leave it. I mean, that means there's something wrong.
What will it take for it to work normally?
It will take a commitment by all of us. It will take a commitment by all of us. It will take either the court, the litigants, the counsel, because there is something in my estimation there is something about the welfare of society that is bigger and higher than my pocket or position. But I think, and I don't know, maybe I may be wrong, but a lot of the times I get the impression that sometimes we are inclined to deceive ourselves into believing that the bigger our purse is, the more we are able to do what we like. In fact, it's been said that some people even think they can buy up government. When people have such mentality, they have no respect for rules, they have no respect for order, they have no respect for community.
I was taking a look at our correspondence report, and one of the things that the judge who's sitting in that tribunal said is that he would not tolerate any time-wasting tactics by any of the litigants in the tribunal. You say that a judge, cannot really interfere or descend into the arena. Do you think that, statements like that could send a warning signal, or do you think that those kind of statements are in order, and will the litigants or their representatives, their counsel, get the message?
Well, part of the, if you like, the tools that the judge uses is prayer for adjournment. If the judge says, I won't tolerate you wasting my time, it gives you the room for you to conduct your case. But if you call a witness and you ask a few preliminary questions and you say, I'm asking for another date to come back and conclude my cross-examination, the judge probably will tell you, look, I have 180 days to conclude this job. If you want to take a break, I'll give you a break for 10-15 minutes, but you have to come back and let's go on with this matter. Some counsel have felt, they feel offended. Sometimes people behave in a way that perhaps some other respectable lawyers will consider unacceptable. But the court will go on. Because the court can refuse your prayer for an adjournment using its or discretion, as the case may be. An adjournment is one of the tools that some people use to postpone a matter indefinitely. So at that stage, the court can tell you, I'm not granting an adjournment.
Are you confident that, sorry Chamberlain, I keep interrupting you. Are you confident that we will be able to, meet the interest of those who will be appealing, well, not just them, meet the interest of all, which is actually the aspiration of most election tribunals, of all the people who are representing their cases before it?
It's possible, but like I said, everybody must do their own part. For instance, just part of these issues I've mentioned that, for instance, pose challenges to a judge, as it were, and they may constitute setback. But even at that, a judge must be industrious, must be knowledgeable, must be incorruptible. You don't watch your back too much if your hands. There are judges who will tell you, you know what, make your application, and they will give you a bench ruling. It's not bothered if you want to go on appeal, because it knows that this case has or appeal decided according to the law. So once, and if you look at election tribunal, as much as one would have wished that it were not so, there have been cases in the past that some judges have been disciplined on account of their conduct in the handling of election petition. That's an aberration. No judge should be found in that kind of. No judge should be found soiling his or her hand on account of taking election petition. And you see, if we realize the seriousness of the process, when this election petition starts, the judges are pulled over from different parts of the country. A lot of the times, other litigants have their cases pending, and those cases, they are kept on hold, especially if they are part-hard matters. Those people also deserve their day in court. So those people who also take their cases before the tribunal, they should know that it's at a very huge cost to society, because somebody silently somewhere is also paying a huge price for that tribunal that is sitting. We focus our mind mainly on the people who are before the tribunal, but there are other several millions of people outside who are not seen, who are paying a very high price for that tribunal to sit. And cases, for me, they are not important because of the people that are the litigants. They are important because of what is at stake for each of the litigants. What is at stake for each person, it may not appear big to somebody else, but it's a matter of life and death for somebody else.
Which also required.
Yes.
As well.
So I think if we focus more on the good of society, a lot of these things, problems will still be there, but I think they can be mitigated.